Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of Equitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're breaking down the most critical court cases shaping the fight against sexual violence, intimate partner violence, stalking, and human trafficking. Each week, we sit down with prosecutors and scholars to break down the decisions that define justice and to discuss the challenges that still remain. Because the law isn't just theory. It's the foundation of real lives, real cases, and real change. Hi, everyone. Welcome back to Just Champions. I'm so excited to be here with you today because I am with an old friend, a professional colleague, as happens in this work. Oftentimes, the people you meet because of your shared passion for the work and your interest in using your law degree to fight the issues that are important to you, in this case, violence against women and children, will bring you into friendships with people. And so we're here today with Michelle Kaminsky. And before we start talking to her, I want to tell you a little bit about her. She is currently the chief of the Gender-Based Violence Division at the Kings County District Attorney's Office, which is Brooklyn, New York. And that means she is the head of the unit that handles sexual violence, domestic violence, human trafficking, crimes against children, and elder abuse. She has been working on domestic violence and in the Domestic Violence Bureau since 1997. And at some point during this podcast, I'll probably pick up the book, I'll have to reach for it, that she wrote, which is one of my best memories of her on her experiences. So, Michelle, I'm so happy that you're here today to talk to us about your experience and about some of the significant issues that impact the prosecution of domestic violence.
Thank you so much for having me.
Of course, of course. So I talked about your background. So the first question I need to ask you is about how your career, over 30 years of experience specializing in these cases, and particularly in domestic violence, how does that impact your approach to these cases or how you train your staff to approach a domestic violence case?
I would say the most important thing that we're doing with training new assistants that come into the Bureau who are coming out of law school, and a lot of them, they don't know anything other than from studying in books what domestic violence looks like. They don't know it until they come in and they're hearing real life stories every day. So we are training our assistants to listen, to be respectful, to understand that when people tell a story about abuse, that it's not going to be in a linear fashion. I know that when I started, when someone was telling me what happened, I wanted to hear the story A, B, C, D, so it made it easier for me to follow what was happening. But we see that stories aren't told that way. They go from A to H to back to F, and that is the way someone who has experienced abuse and trauma, there are reasons why they are recounting events in this way, and to be patient and let people speak and not interrupt them. Some really basic things about being a good listener as the starting point, because really once you understand what has happened, then you could, as a lawyer, start looking for corroboration. What evidence do I need? How am I going to build the case?
How do you pick the type of, or what qualities are you looking for, I guess, in either current prosecutors who want to come to your unit, or if you're involved at all in the recruiting process, what are you looking for in law students or others who are applying to the office, who are applying to handle the cases that your unit handles?
So we were really fortunate over the last few years. I would say over the last 10 years, we are seeing more and more assistants applying to the office who specifically want to do this work, which is very different than when I started in the office in 1992. There was the belief around domestic violence. This is pre-Violence Against Women Act, pre-New York State mandatory arrest law. The way domestic violence was seen, it wasn't a serious matter, and no one wanted to go handle the cases. And if you were sent to the Domestic Violence Bureau, which was a very, very small bureau at the time, it was seen as a punishment. You were not a strong assistant, and that would be a place because it really didn't matter whether you succeeded or not, because that was how the cases were looked at, that they weren't important cases in the system. It's been a complete sea change around that. The Domestic Violence Bureau is one of the largest, if not the largest bureau in the office, with incredible resources in the bureau in terms of support staff and actual prosecutors. So to answer your question, I would say people are going to law school because they have a commitment to do this work, which is fantastic. So for a long time, what would happen is, because we have about 10,000 cases that come into the Domestic Violence Bureau every year in Brooklyn, in order to keep caseloads manageable, we have a lot of assistants that get sent into the bureau. And often the new entering class, all of them would be sent there because of the needs of the bureau. I mean, they would be told, you're going to the Domestic Violence Bureau. Now we see a lot of assistants volunteering, I want to go to that bureau. So it's
amazing. I mean, first, just listening to what you're saying about 10,000 cases coming in. And of course, you are in a huge part of the city. And when people, though, always think about crimes as this big circle of the incidents of crime, many of which is not going to be told to anybody, maybe not even a friend. And then if you think about that smaller number of cases that actually get reported and then actually come into a prosecutor's office, I just think it's important for people to think about the delta, the difference between those two. And I think over the course of your career, one thing I've always loved about you, and I think this is probably a testament to the change you've seen over your unit, is you've taken the time to explain why these cases aren't just cases that happen in the home and not dangerous. If people can't see me, obviously, by my little air quotes on not dangerous. I mean, we know how dangerous these perpetrators are to the people in the home, their partners, children, older people, and how dangerous they are to the community. And in fact, in a couple of the earlier episodes, one in particular in domestic violence homicide, one of the cases involved, the abuser's partner's friend who was murdered because she was basically trying to protect her friend in terms of protecting where she was. So I think that understanding of why these cases are so important, that's something that's always impressed me about you, because you're so methodical, you have the compassion, and yet you're able to break these things down. And I want to ask you a question, because you talked about how the reports aren't linear, even though we want them to be like A through Z. But I know when you're prosecuting in trial, you do have to, you've got to bring them together in a cohesive narrative so that the fact finder understands. How do you do that? What's your strategy?
So that very first interview is where the assistants understand that when they have to listen and go back after that they've heard after the complainant has told them their story, and even if it's not in a linear manner, then they go back and they ask questions. By the time that the case is going to trial and there's preparation, the assistant is preparing the questions in a linear manner to tell the story and working with the complainant. So it's different because now here are the questions I'm going to ask you, and those questions are flowing in a chronological way because the fact finder on the majority of these cases, it's a jury. And a jury, they're just people in the community who get a notice to come in and serve on jury duty. And we want to be able to tell a compelling story and a story that makes sense. So the storytelling through the facts is very, very important, and to provide context that's another thing that we're teaching the assistants. These things don't just happen in a vacuum. It's not that one-time incident, that it's very important to have context to get the prior history of the relationship, uncharged crimes evidence, so that we make motions for the admissibility of that uncharged crime evidence. But we're doing all this because the jury needs to understand what's been going on in this relationship that led to these criminal charges. Otherwise, a lot of times it doesn't make any sense why on this day, if they've been together for a longer period of time, that it just happens in a vacuum. And we know that's never the case. So really, the context and the history of the relationship is also critical in our training of the assistants to understand that, so they could bring forward a compelling narrative that they're telling, so the jury really has an understanding of the history and how everything that they're charged with came about.
Yeah, and it's interesting because you even said it, the Violence Against Women Act. And then, so it's, 30 years old, a little bit over now. And even before that, there were these massive grassroots efforts, most of them led by advocates. But there has been media, there's been so much information about domestic violence. And yet, just as you're describing the process of prosecuting a case and thinking about the jury, it isn't surprising that you do still have to explain the dynamics and still, and this is maddening, but still explain why someone didn't leave, why they didn't report, why they may be minimizing injuries. And are you still finding that that's a barrier you need to overcome when you're in court?
We still are jury selection. We have a line of questioning that explores this very thing, because I think when people are sitting in judgment, it's very easy not to see themselves in that situation. They hear it and they're like, well, if it was so bad, I would have left. Why did that person stay? So a colleague of mine developed, Arlene Markarian, this a great line of jury selection that brings the jury in, the potential jurors, to try to place them in a situation. And then we use it in summation. We get back to it where we ask individuals, if they're walking down, we ask prospective jurors, you're walking down the street, a stranger comes up to you, punches you in your face, and takes your wallet. Would you all agree a crime was committed? The majority of the jurors, if we ask, would you call the police? Yes, I would call the police. Now you switch the facts and say, let's say it was your brother that came up to you, punched you in your face, and took your money. Would you agree a crime was committed? Now all of a sudden people are being, well, my brother did it. Why is that a crime? I'm not sure if that's a crime. Well, what's the difference? You were assaulted and your money was taken. Well, it was my brother. So why is that different? Because I love my brother. Would you call the police on your brother? No. Why not? Because I wouldn't want my brother to get into trouble. So that's how we're exploring. These are the very same things that our complainants are going to say on the witness stand. Why I didn't call, why I thought maybe we could work things out. I wanted, the person to get help. I really tried to handle it on my own. I didn't want to bring in the police. I didn't want to see them in trouble. And then when we get to summation, our closing arguments, we're able to say, look, we spoke about this during jury selection, and you even said how difficult it is when it's your loved one to bring in the police. And I think that when you pull them in and you're talking to them about what they would experience, what they would feel, there's a better understanding.
Yeah, so much more effective than, do you believe a domestic violence victim is a victim of a crime, right?
Yes, exactly.
So I'm getting it. So
yeah.
I mentioned it earlier, but just again, these are not plugs, but these fascinating, amazing people, you, Michelle Kaminsky, took the time to write this book. And in going through, and we've known each other, I think if you think I'm lying, I have marks in this book from when I got it back in 2012. And I want to ask you, because you have so much on your plate, more than a full-time job with heading a unit, prosecuting cases, even at the time. I know you teach because that's some of the places I've been on panels. We've run into each other. I know you're active in the field, being an expert and offering your expertise on these topics. Why did you write a book about your experience? Because it's incredible to share it with all of us.
So I wrote the book because I was very interested in how we got to that the criminal justice system was responding to domestic violence and the central focus of the criminal justice system. And yet, at the same time, I was seeing so many complaining witnesses didn't want what we were offering in terms of criminal prosecution. So I started, how did we get here that we have this response that a lot of our complainants are saying is not meeting what their needs are? And this central focus of prosecution and conviction rates as being a measure of what success looks like having a case in the criminal justice system. Is it only successful prosecutions or other things that a domestic violence prosecutor can do that doesn't equate with a conviction that still equals success? And how do we address that and work with the complaining witnesses and hear what they're saying in terms of what they want or they don't want for a very long period of time? We went from a place where I said, when I started in the office in 1992, if you were sent to the domestic violence bureau, I think it was a unit at that time because it was so small, it was because you were considered a problematic assistant and the cases weren't taken seriously. Then fast forward with the Violence Against Women Act and all the funding that came in to build up the Domestic Violence Bureau and have all different innovative programs that we started taking these cases very, very seriously. And we had pro-prosecute, not just pro-arrest laws, but pro-prosecution policies in place. So it was that extreme, the thinking that it has to be prosecution, trial, conviction. And now there's been this leveling out, I think, at least here in Brooklyn, in the city, that having a more expansive view of what success looks like in these cases, that it is not measured just in conviction rates.
We've touched on so much of the context, and because so much of that context can cause a victim not to be able or willing to come to court, I think that that's the segue to sort of raise our case of the day, which is Crawford v. Washington and its progeny, the fancy way of saying the long and never ending, because teaser, there might be one more coming up in the next few sessions to be heard on confrontation and the confrontation clause and how it's analyzed when we're talking about the admissibility of a witness's statements when those statements were made out of court, basically how it gets analyzed. And of course, this is, as you know, this has impacted both actual, when I say testimony, the words that someone was, has said outside, and it's been applied to lab reports as well. So there's a lot of landscape we have covered in some of this series and we could cover. But for this one, I want to ask you, we'll just start with Crawford, and I'm not going to really get in the facts of that one, but how did that decision change, if at all, how you prosecuted domestic violence cases?
So I will say when Crawford came out, there was a tremendous fear that would impact our ability to try cases in court, that we would lose evidence. We rely a lot on excited utterances that our complainants are making in 911 calls and when the police respond to the scene. as a hearsay exception to use those statements at trial. And the belief was when Crawford came out, because there were tremendous on a state level, national level, there were training programs, there was a lot of writing. What does this mean for the future prosecution of domestic violence cases? And I will say that it did not harm us here in New York. We got very good case law from our highest court, the New York Court of Appeals, that found that statements made to the police, there needs to be an analysis. And if the questioning of the police or the 911 operator on a 911 call, or the questioning of the police when they're responding to a scene is to address an ongoing emergency, then those statements are not considered testimonial under Crawford, which implicate the Sixth Amendment. And that is our argument, that the 911 call and the police response at the scene, that a lot of times this is to address an ongoing emergency. And we're very successful in getting those statements in under that theory. So that concern and fear that Crawford would undo all the progress that had been made in presenting domestic violence cases at trial, it didn't come to pass.
And I'm going to go through with you sort of the little, the very precise things that you did. It's just, you were very kind, because as you probably, maybe we have the PTSD, because if you remember that famous line in Crawford of, testimonial statements aren't admissible unless the declarant, the person who made them, basically is unavailable, and there was this prior opportunity to cross-examine, but quote unquote, we'll leave for another day what that definition of testimonial was. And so there was, I think, for jurisdictions, and I think you and I had a very similar experience, for jurisdictions that already had strict hearsay analysis, which is something different. It is also an analysis of an out-of-court statement, but it's something different than testimonial. Under Crawford, if the statement is deemed non-testimonial, so not in violation of the Confrontation Clause, you'd still have to do a hearsay analysis. But I would say for those of us in jurisdictions where that hearsay analysis was really strict for out-of-court statements, I feel like we were better prepared, maybe not as terrified, because we already had learned the arguments, the strongest arguments to try to get these statements in. But it was a very different analysis. And as the cases progressed, for everyone to understand what Michelle, and her team had to do at the time, because I wasn't prosecuting anymore when these cases came down, but you were. And so we went from that piece to Davis and Hammond, which were really the next in the line. And those were domestic violence cases. And very briefly, because I do like to talk about the victims in the cases, and both Davis and Hammond were domestic violence cases. In Davis, the victim was on a 911 call because she was being beaten up, and literally first it was disconnected. I think the operator calls back, and then she's reporting what happens, to include her abuser fleeing the scene. And in Hammond, it was a little bit different. And that was the case where the perpetrator had left the scene. And by the time the victim left the room, and by the time the police came, the perpetrator was in one room and the victim was in another area giving the statements. And those two decisions came out differently. Those two statements were analyzed differently, and the court kind of got its way to this emergency test of if you're basically reporting an emergency, more like this 911 call, to where you're reporting something for potential future prosecution, more like this Hammond v. Indiana. But I always feel like what irks me about that Hammond v. Indiana case, because you and I both know this, the facts in that case, the perpetrator's in the other room, and during the course of the police taking the statement, the perpetrator's coming in and trying to interfere with that statement. And we both know, and both of our friend David Martin was on a few episodes earlier, what intimidation looks like. And you don't have to say to someone, I'm going to kill you, to be inflicting that kind of intimidation and to making them unavailable and interfering with them. So I'm always like, if the facts, you always learn from things and think, okay, what could we learn from this so that if these kind of facts ever arise again, we can really use what we know about domestic violence dynamics to demonstrate why emergencies can still be going on. I mean, it's not going to be in every case, but in some cases, just because they're separated, just because the police are on site, there still could be something happening there, just from what we know.
Yeah, no, I hear you with that. And I would say another sea change that's come about is the use of body-worn camera and having the footage. So as to the analysis of if a statement is testimonial, it's a two-step process. First, we have to see, do we have a hearsay exception? So is it an excited utterance? And even if it's an excited utterance, is it a testimonial statement? So that's how we're analyzing it. But with the body-worn camera footage, we could have the police are turning on that footage as soon as that they're interacting with the victim at the scene or the suspect who's at the scene. So the camera's on, you're hearing everything that's being said. Even if you reach a point in time, these cameras could be on for about an hour, that what the victim has said is no longer considered an emergency. And now the police questioning looks like it's to prepare for future litigation. We could redact that portion, the audio portion, so you don't hear what it is that the victim's saying. But the actions of the suspect going back and forth, maybe the faces that they're making, that intimidation that you're talking about, we can move that in. So it's just that the audio piece is being left out because you're right. We know that there is incredible intimidation in these cases. And earlier when I spoke about, my thinking process of what led me to write the book and this idea that we have, a lot of times victims that don't want to participate in the criminal prosecution, the reason for that is different. In some cases, they don't want to participate because of their level of fear that what is the perpetrator going to do to them if they continue with the prosecution. So you're right. We know very high levels of intimidation, not just by the perpetrator of the abuse, their family members, sometimes even the victim's own family putting pressure, why are you bringing charges against the father of your children or the financial provider?
No, 100%. And that's why the tools, I go back again to the prosecutors who handle these cases. Working with the victims, trying, like you said, there's so many things that don't appear on a case decision or on a trial transcript when you're down in the lower courts. People may not realize, you're not going to see a lot of appeals on cases because there may be a not guilty. So the prosecutor's not getting a chance to appeal anything unless it's an interlocutory. So you're already from the beginning talking about how you're bringing together all the partners to address victims' needs outside the courtrooms. And then Crawford, I think about the prosecutors, again, preparing to be able to make these legal arguments, to understand all of the different evidence. And it's understanding the context, all the things that you talked about, Michelle, like how you have trained people over the years and how you train them to look at the context. It's all important to understanding at the moment. This isn't trickery. It's just really fully trying to illustrate for the fact finder what is happening at the moment that a victim is making a statement, sometimes with very obvious injuries and in the middle of an assault, sometimes where it seemingly has passed. And we know many of these serious assaults don't leave visible injuries like strangulation, or if they do leave indicia like hoarse voice or the screaming and excitement, the petechiae still missed even with all of the training. So really trying to give your prosecutors all the tools they need so they can sit in court and make these legal arguments, but they're all based on the facts of these cases. So we try, and again, for the show, people listening, the show notes are going to have a lot of these cases and articles written on them because they did evolve over time. And Michigan v. Bryant sort of, I guess, really hammered in the ongoing emergency and I guess what's in the receiver, the person taking the statement's opinion, which I think made one of the justices unhappy in that one of the dissenting justices that was considered in part of the holding, but be that it may. But these cases continue to evolve and they continue to incorporate, I feel like, facts and analysis to really get to justice. And I wondered if you had anything, like any other points with Crawford, Davis, and Hammond, Michigan, that you prepare your staff for as they're getting into trial and maybe dealing with this issue of a victim who's not there to testify.
So the concept of forfeiture by wrongdoing, looking at why doesn't a victim, if a victim was cooperative or was willing to participate in the prosecution and now is no longer returning telephone calls, isn't coming down to appointments to meet with the prosecutor, what has happened, that requires an investigation. Just because your victim on a case is not returning your call anymore, our assistants are trained, you need to investigate and determine what's going on. We are fortunate. We have a staff of detective investigators here in the Brooklyn District Attorney's Office. If we have the person under arrest is in on bail, the jailhouse calls really tell a story about what's been going on. We listen to the calls to see, are they reaching out to the victim and putting pressure on them in some way not to go forward with criminal charges? I would say over the years, listening to the calls in the context of domestic violence, that what intimidation looks like isn't the same on non-domestic violence cases between strangers. In DV cases, intimidation is rarely about you go forward, I'm going to kill you, I'm going to get someone to harm you. It's about killing them with kindness. You know, I want to be the man you want me to be, but I'm sitting here in jail and I can't show you. And if only these charges were dropped, and if only you reached out to my lawyer, if only you told the prosecutor you don't want to go forward. We see a lot of that in the calls when someone is in jail. And we are moving forward to hold a hearing, to seek a hearing in court, to say that the defendant has forfeited his Sixth Amendment right to cross-examination, and the reliable hearsay, statements that the victim made to the police, statements in New York. We put our felony cases into a grand jury. The grand jury testimony should be admissible because the reason the victim doesn't want to participate anymore is directly linked to the tactics that this defendant has used to influence them, to manipulate them, and to coerce them out of participating.
I love, again, and this is also a case I'm going to mention, not to talk about today, but for sure I'm having you come back to talk about it because you're over. I mean, we're talking a lot about, Crawford applies to cases with victims of all ages. We were talking a lot today about cases with adult victims. Something to remember is that there's been some case law with victims who are children. And the only reason I want to highlight the facts of this case are just to leave people with the subtle types. It's not even subtle, but the sometimes could be overlooked intimidation that's happening if we are focused on blaming a victim, maybe for their lifestyle that we feel like makes them deserving, maybe makes them not the perfect victim that we want, which is, again, as prosecutors, we reject this worthy victim concept. But in Ohio v. Clark, which was, I think it was a 2015 case, this was a case with child victims. And it's interesting, it had nothing to do with intimidation of the mother. But this is a case where the children who were left with the perpetrator, who was the partner of, he had sent his partner, his victim, girlfriend, out to work for him in sexual exploitation. Now, again, it's like we know so many things, and I'm not gonna sit and say I don't have these case files in front of me. We never sit and talk. But you've got someone who's at the very least sexually exploited person, and at the very worst trafficked. And she's out of the house. She's away across the country, and her children are with her exploiter, one of her exploiters, because I would say the buyers are too. And these children are getting beaten up by this individual. And in fact, this is a case that dealt with the statements that one of the children made to the teachers and others about the abuse that happened. But it's just another reminder of why I think two things that you've done are so remarkable before we wrap up. The fact that your unit handles all of these cases together, because understanding one of these crimes, domestic violence, sexual violence, child abuse, elder abuse, human trafficking, stalking, it helps you understand all of them and build tactics around all of them and makes you better able when you get cases in front of your, on your desk to maybe see links that in other offices may not be seen. So I guess I just tell you this because I want you to know I'm going to invite you back because I want to have a long talk about this and how it's impacted your work in child abuse cases in a different season.
Okay.
If that's okay.
Absolutely.
Okay. So I am so grateful you were here today. I think the world needs more Michelle Kaminskys. There are amazing Michelle Kaminskys out there, other people, and we've talked to some of them, and some we hope to talk to, and some we're never going to know their names, but they're doing this incredible work every day. And I'm hoping that people who listen to this and who've taken the time to listen really understand the good you can do as a prosecutor, the compassion, the holistic work, the interesting legal challenges. So I like to ask 3 quick questions of everyone that comes in, if that's okay.
Sure.
Okay. So the first is, what is the hardest lesson you've ever learned in a courtroom?
To expect the unexpected.
That's right. Couldn't have said it any better. That's why you over-prepare, right? Second, what would you tell young Michelle Kaminsky about this work?
Oh, wow. That's a hard one. What would I say? Don't get discouraged that you are helping people. Don't get discouraged in the moment with something. There's a bigger picture. You just can't see it yet.
So what's given you that attitude? What keeps you coming back, even when it's tough, even when you're discouraged?
Because I think it's for a greater good that, especially I could say, we're implementing policies here in Brooklyn that we have an excellent district attorney, Eric Gonzalez, that is all about innovation and the creation. By creating the gender-based violence division, he understood what you just talked about the intersection between all these forms of violence that you spoke about. And then we have a chance to not only do this work here, but model best practices to be able to send the message that conviction is not the only measure of success in these cases, that there are other things we need to be looking at too, and other work we need to be doing, and to educate our prosecutors. And they go out, they leave the office here. I know you had someone on from Denver, Stephanie Fritz, that came out of the Brooklyn District Attorney's Office. So it enables us to send out people into the world too, from a big office going to other offices. They leave the state. So we're making an impact. That's a long-winded way. I believe the work we're able to make an impact based upon the work that we're doing here.
Well, you've made a huge impact in your career. Thank you so much.
Thank you so much for having me and for everything you do by having this podcast and highlighting the issues outside of Brooklyn.
Thank you.
Okay. Bye-bye.
This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about Equitas, please go to equitasresource.org. That's AEQUITAS resource.org, or follow us at Equitas_resource on Instagram. This series is executive produced by Jennifer Long, Equitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.